Okay, so now we're talking about the trust doctrine. So we're on chapter 14, trust responsibility. We can begin by looking at, where does the trust doctrine begin? Well, John Marshall, we usually think, right? With the John Marshall trilogy of cases. This will work a little bit better. And Marshall, of course, was pointing back to the Northwest Ordinance of 1787, where the Northwest Ordinance basically says that Congress, or the United States, and Congress assembled will always observe the utmost good faith toward the Indians, and the laws created for them will be founded in justice and humanity, et cetera, et cetera. So John Marshall was pointing back to the Northwest Ordinance of 1787. We're going to talk about that. One of the most important trust responsibility cases is the last one we'll look at. Your textbook author starts off by saying, well, is the trust doctrine really something that is legit? And you might think about this. If the government decided not to do this, it would be paternalistic. So if it did, it seems like it's violating its trust responsibility. This is the case in which the Seminole tribe in 1942 brought federal suit, basically saying that you can read this, but essentially the Seminole tribe was under the government of the Seminole tribe was corrupt, and it was largely being held up by the federal government. And the Seminole leadership was guilty of embezzling federal funds that were supposed to be used, directed for the benefit of the tribe. So in that case, in Seminole Nation versus United States, 1942, we have something pretty interesting. The Seminole Nation, oh, by the way, this is a way to read some of these court cases, if you can see this. Seminole Nation versus United States, those are the parties. The number here and these abbreviations refer to, if it says U.S., that's the United States Reports, which is the reporting authority on the Supreme Court cases. So 316 U.S. 286, this is the volume, and this is the page where the case starts, where the opinion is located, and of course the date. So 316 U.S. 286 is Seminole Nation versus United States. And usually the petitioner or plaintiff is in front, but a lot of times these will become, it depends on who wins the case. So in the Seminole Nation versus United States, the United States, I'm not sure exactly how the Supreme Court took this case, but sometimes they'll switch that around. So if say the petitioner loses the first round at the district court level, and then perhaps loses the circuit court level, or maybe if the petitioner wins and then the respondent appeals and wins the appeal, but then the original goes to, sends it, basically appeals to the Supreme Court, then they'll keep switching these things around. So anyway, basically don't worry about who's asking who for corrections. the neat thing about this case was that the Seminole Nation basically says that, you know, the United States federal government was supposed to be watching over the assets of the Seminole Nation, and it failed in that capacity. It was a failure of oversight of those funds. And most of the time, issues of the trust responsibility come down to money. They come down to monies that are owed tribes or individuals within the tribe, especially individuals. So to understand this trust responsibility idea, we need to first kind of understand what is meant by trust in a legal sense, okay? So in a trust, a trust is basically a holding area or a status of some asset that's being held by a third party for the benefit of the second party. So most of the time when we're talking about trusts, we're probably talking about someone willing assets to their descendants, okay? So in the case of someone who, say for example, a mother and a father who have, say, 3 children ranging in age from 2 to 6, say this couple dies in a car accident or dies of COVID or something like that, leaving these 3 children to as orphans. Their assets, if they were prepared, their assets may have been placed into a trust, and that trust would basically hold all of the things, all of the assets that their parents had, but they wanted their children to have them, you know, split 3 ways. But if they're minors, if they're children, then it would make sense for those assets to be held for the benefit of those 3 children until a time that those 3 children are responsible enough to be able to take on those assets. Okay, so in the case of that sort of trust, the parents would have been what we call the settlor. It's kind of a weird term, but it's like settle, but settler or settlor. And then the settlor would assign the assets to a third party who is trusted to watch over those assets, and that person becomes the trustee. So there's a settlor and a trustee, and the children who are for whom the trust is even, you know, is created, the children are referred to as the beneficiaries. Okay, beneficiaries. So I should probably be writing all this down. It might kind of make sense. So we have the settlor, the person who is willing or passing assets. Two T's? Money. All right? Money and property and that sort of thing. The settlor dies, and when that happens, then the trustee, prearranged by the settlor, the trustee essentially has control over those assets. Okay. And the trustee's job is to safeguard the assets. I think it's just 1 G. Okay. So the trustee is trusted to watch over the property or the money or whatever that is going to be held by the trustee until a certain period of years. And that's when the beneficiaries reach an age of, and there's a term for it, but let's say the beneficiaries, let's say that the trust or the settlor originally said the beneficiaries will receive this property after age 27, random pick, but it's often like late 20s, early 30s, something like that. Okay, so once those beneficiaries, once a beneficiary reaches age 27, then they're going to receive, and this is all dependent on the trust language. They're going to receive their share of it, of the assets. Once all of the assets are distributed to all beneficiaries, the trustee's job is over. So the trustee, this is after so much time, the trustee is obligated to safeguard those assets, and that's referred to as sorry if you can't see that over there. That's referred to as a fiduciary duty. Okay. Now, and in trust law, and most states allow either an irrevocable trust or a revocable trust. That means that the trust, if it's revocable, which most of them are in Oklahoma, then they can be amended or changed after the settlor passes, okay, or at least sometime if there's a problem in some way. But the trustee is held to a very high standard. That's the point of all this. The trustee has to be held to a very high standard, and is initially trusted not to squander the assets for himself, and in fact usually given the job of trying to grow the assets by investing them or something like that. So the trustee is the overseer of the assets for a period of time until beneficiaries become eligible for them. So in this case, the settlor in the case of the Seminole Nation was basically the Seminole Nation. And you might even think of it as kind of the Seminole Nation and its ancestors, right? And its land. So that's the settlor and the land or the assets are taken into trust by the United States federal government once the tribe is federally recognized, in fact. So you have the federal government in the role of trustee. So the beneficiaries in this case would be the living Seminole people. Okay. And this was the basics of the federal trust relationship. So what Seminole Nation did was it basically incorporated United States trust law, the basics, the foundational concepts of United States trust law into United States Indian law. That's what the importance of Seminole Nation versus United States 1942 is. And by incorporating trust law into it, that creates the condition that the United States must maintain a high degree of responsibility and in carrying out its fiduciary duties for the tribal members. It's a really important case because, as we'll see, federal trust can actually change. It can, the trust responsibility of the federal government can actually change over time. And I'll show you why. Now, I'll say another thing. In most actual trusts of individuals and families, a lot of times if there's not someone that the settlor trusts enough, crazy old Uncle Charlie might spend it all on whiskey, something like that. So oftentimes there are professional trustees in the forms of banks. Okay, so banks are good at holding money and watching over assets. And in the case of banks or in individual trustees, there'll be an amount charged for that service. So that's possible too. So it can be there can be a charge against the assets in the trust in order to maintain it. Often the case. Well, with the federal government holds the trust the same way. So assets that are being managed by the federal government will sometimes, the cost of that management of the trust assets will sometimes be charged for that management, which sounds kind of strange, doesn't it? But it will, as we'll see. Okay. There are some really good questions in this chapter, sort of philosophical questions. In the case of Seminole Nation, the government was kind of between a rock and a hard place, because if it decided not to follow up on this case, or decided against it, then they would be sort of guilty of paternalism. If they did, then it would, I said that in reverse. Basically, the government's either going to be in violation of the trust, or they're going to do something for the tribe. So anyway, that particular case was, you didn't really get an excerpt from it, but it was important. All right, Supreme Court case. In the first one, this one's called United States versus Mitchell, and there are actually about 7 different cases involving this particular situation. But we're only looking at the second to last and the last case, because they finally reached a settlement. What this is about is Mitchell 1 and Mitchell 2 are the cases. Mitchell 1 is 1980 and Mitchell 2 is 1983. This claim had started off in the United States Court of Claims, and it went back and forth because it involved actually a group of Indians who were Allottees, and then basically an association of Allottees of the Quinault Indian Reservation in Washington State, northwest Washington State. All right, so a lot of this, especially Mitchell 1, has to do with the General Allotment Act. Okay, so this case determines a lot of sort of the definitions of the reasoning and the purpose of the General Allotment Act? Well, I kind of thought we already knew that, right? What was the purpose of the General Allotment Act? What did it do? It distributed lands from reservation, from common held property to individually held allotments. And then after a time, those allotments, it was intended, would be turned over in fee simple. Now, that period between the designation of allotment and the receipt of a patent from the United States, that's a fee simple patent, that period is known as what? You remember? For most tribes allotted under the General Allotment Act, it was 25 years. A 25-year period of restrictions, okay? A restriction upon alienation. And I've made a lot about that, because restricting the land and not allowing it to be sold, number one, was paternalistic, and the whole intent was that, one intent was that it would be with that individual for 25 years. But the primary reason was, according to the government and according to this, the primary reason was to keep it from being included on the state tax rolls. So if that allotment was issued and for 25 years it was not on the state tax rolls, then that was considered a long enough period for the allottee or descendants of the allottee to build a farm, or at least to learn how to farm, or at least to utilize the land in the sense that non-Indians utilized the property ownership, or utilized property. So the restriction period is what's at stake here. And in the United States, the case began with the United States Court of Claims and this group, Quinault Group, petitioning the United States Court of Claims, saying that the federal government owed them money for the timber that it took off of their individual allotments. Okay, so these allotments are held in trust. They're restricted allotments. The land is essentially Douglas fir and spruce and heavy timber, very heavy timber, that's utilized by the, it's actually being sold by the Forest Service, and at least on Indian land, it's going to be managed and sold by the Bureau of Indian Affairs Forestry Division. Okay? You know that existed. So the Bureau of Indian Affairs, along with a lot of other federal agencies like the United States Forest Service, which is the Department of Agriculture, the Fish and Wildlife Service, also Department of Interior, the General Land Office, or the Bureau of Land Management, BLM, the National Park Service, all of those federal agencies have lands where there is timber to be managed. The National Park Service, it's usually not logged, but all the rest of them, there's usually some kind of timber that's being sold off of that public land. So in this case, you have the Bureau of Indian Affairs selling timber from these lands that have been allotted to Indian tribes. Now, a lot of those allotments most of the allotments were not inhabited, they were just owned. Okay? So the Bureau of Indian Affairs is selling the timber to private firms, and then taking that money and putting it back into the Bureau of Indian Affairs account for the tribe to manage their affairs. So basically it's attempting to manage that trust by investing and selling, and so it might be selling that timber, but then it'll take the funds and place them back in some sort of investment of some sort, so that it grows the asset. And then those would be distributed at some point for the use of the Indian tribe. Well, the Quinault tribe finds out that the Bureau of Indian Affairs Forestry Division is selling timber at a rate lower than the market rate, and has been for years. So basically the tribe, the allottees, are not getting their market value of the timber that's on their property. Okay? So they claim that the federal government is shirking its fiduciary duty. It's not living up to its fiduciary duty. So they're suing. They sue in the Court of Claims for the loss of the timber, and then also the interest on the loss of that money. Well, they lose, I think, at the district court level. They appeal at the Circuit Court of Appeals level, and they win. And then the United States comes back and appeals to the Supreme Court. Okay, so this is why it's the United States versus Mitchell. Okay? Initially, the Mitchell group, they were the ones starting all this. So in the United States versus Mitchell, the first case, Mitchell number 1, let's see here. The Department of Interior appeals to the Supreme Court. And the Supreme Court opinion on this was that basically what it did was it came down to this. The Supreme Court's opinion was that the General Allotment Act of 1887 cannot be read as establishing, see my own notes, as establishing a trust obligation to the tribe or to even individuals. And the reasoning for that, and this is Chief Justice, or not Chief Justice, but Associate Justice Thurgood Marshall does this one. He says that, okay, the United States, the General Allotment Act itself did not create a situation in which the federal government had a trust obligation to those individual allottees. Why? Because the purpose of the General Allotment Act was to distribute individual property to individual Indians for farming and ranching. Okay, isn't that crazy? So this reservation was in the Pacific Northwest, in the Olympic Peninsula of all places. It was very mountainous and extremely heavily timbered. And there really wasn't any farmland, but they had a reservation in the woods, and so they divided up these allotments, and they weren't even very big. They're like 80-acre allotments, and the tribe then had that as their sort of timber assets, timber to be sold. Federal government manages it, sells the timber for the benefit of the tribe, the benefit of the individual Indians. But the individual Indian folks say, that's way too little, etc. And they also make a claim that the federal government is the General Allotment Act forced the tribe to allot. We didn't want to do this, but we had to. So now the federal government's stealing, basically stealing our assets. All right, so that's Mitchell number 1. Now, interesting thing about this was that, in Mitchell number 1 at least, that the Department of the Interior, which was pretty good at, the Department of the Interior and the BIA was managing this. They didn't have a lot of expertise compared to like the U.S. Forest Service. So there's kind of an argument there. But Thurgood Marshall, in his opinion, which basically, the tribe lost. They didn't win their case. But in the opinion, what Thurgood Marshall said was, the Allotment Act itself didn't establish a trust obligation. But, he didn't really say this, but kind of indicated if there were other laws that had been passed over time, it may have created a trust obligation. So, a couple years later, we get Mitchell 2. And in this one, what was brought out in Mitchell 2 was that the federal government had, between 1887, or at least between the allotment of the tribe, of the reservation, and whenever this was happening, the federal government had passed different, the Department of the Interior and the Bureau of Indian Affairs Forestry Division had established different policies. And those administrative rules within the Department of the Interior strapped more and more responsibility on managing forest for sustainable use in the form of the most sustainable, or at least the optimal use of the property. So basically what happened is the federal government administration agencies created more and more stringent rules, which they then violated, okay? And so even though the allotments, the allottees weren't even knowing about this, because of changes within the agency, that created, those changes, those administrative rules, created a situation in which there was a greater and greater trust obligation. So Mitchell 2, I think, is really interesting because the United States Supreme Court says, well, when the federal government's agencies change their own rules to have greater and greater stringency, and if they're not following those rules, then you are losing something, okay? And that's exactly what happened. In this case, they won Mitchell 2. Our tribe did. So it was, and the name is the Division of Forestry and Wildland Fire Management of the Bureau of Indian Affairs. So even though allotment did not create a trust responsibility, later statutes and later administrative rules actually did create a greater trust responsibility, and that got formalized into something called an ETO, an enforceable trust obligation. So enforceable trust obligations can arise, and we'll see more of that in later laws associated with water rights. So water law is affected by this, as well as timber and other natural resources are affected by it. Okay. Black Hills, or United States versus Sioux Nation. This is a very long example, very long treaty, or a very long case. It's a Supreme Court case. And it involves the United States Congress abrogating a treaty. It involves a treaty that is considered to be illegal by the tribe. And it's kind of like the Cheyenne-Arapaho Treaty, where there was a requirement of 3/4 of the adult men of the tribe had to vote for not allotment, but giving up land. And so this was, without going into the case itself, the story of the case, there was an agreement in 1877 that everything's pretty much based on. And 1877 is after the Fort Laramie, the Second Treaty of Fort Laramie, which is 1868. Remember that one? And then it was also after a treaty from 1874, I think it is. The 1877 treaty, which is after the Black Hills Gold Rush. And so the issue here is whether or not the Black Hills were a taking, and it has to do with the value of the Black Hills and compensation for that land that was taken. It created something called the good faith effort test, or the Fort Berthold test of 1968. And this was a different example that I think, did we already look at that one? I think we did. But essentially this good faith effort test is one to determine whether or not the government was acting in a fair light. In the case of the Sioux, you probably know that the last time this came to court was in 1980, and the United States government had assessed the value of the Black Hills and the taking. They assessed the value of the taking plus interest to be $200 million. Okay, and the tribe said, no, we're not going to take that. We're not going to take the money. But federal law only allows compensation monetarily, not by handing land back. All right, I was hoping I think we will get a little farther. The Cobell litigation is something that got started under, it got started back in the, I think, Bush administration, and it was originally referred to as the Salazar, maybe. Anyway, it was a class action lawsuit filed by individuals who mostly had oil and gas royalty money from restricted allotments. In the Bureau of Indian Affairs, there was an entire office dedicated to what are referred to as individual Indian monies, IIM. And what those were they were essentially the royalties from oil and gas wells and oil and gas production on lands within the lands that were held by individual tribal members, restricted lands. Remember that any restricted land, any asset or use of that restricted land through leasing has to run through the Bureau of Indian Affairs. It has to be approved by the Secretary of the Interior, as I say. Okay? Nothing happens on restricted Indian land, on trust land, without approval of the Department of the Interior. So if you listen to these cases, you'll hear the lawyers often referring to as the Secretary of the Interior, or he. Okay, they'll refer to the government branch as he, basically the Secretary of the Interior. So the Cobell litigation and earlier, they say litigation because it's not just one case. It refers to this class action lawsuit by thousands of people who claim that their royalty money, which was supposed to be managed by federal government, by the Bureau of Indian Affairs, for their benefit, have been mismanaged. And when they subpoenaed the Bureau of Indian Affairs for records, the Bureau of Indian Affairs couldn't produce the records. They couldn't produce, essentially they couldn't produce an accounting of the assets that these individuals had. So in other words, they were absolutely incompetent when it came to managing the fiscal affair, or managing the money coming off of allotted lands. Okay? There's an enormous amount of money that's administered by this individual Indian Money's office. But they couldn't even really estimate how much had been lost. There are some estimates. Your textbook author identifies a figure of like $46 billion of the estimated losses to individual Indian money accounts because of mismanagement. It was eventually ruled in, and there was Congress passed something called the Claims Resolution Act of 2010. And I remember when I heard about that on the radio, I was like in the Calton Center parking lot, and I said, I can't believe they actually arrived at something. But it was the settlement to the class action settlement was $3.4 billion. The lawyers got a lot of that, but this was nowhere close to the estimated amount that they think they actually lost. So anyway, the Cobell litigation was sort of the ultimate in federal failure to live up to the trust obligation. Okay? All right. Let's move on to Indian title and talk about another case. This is actually, let's see here. Did I talk about this one already? Maybe not. All right. This particular chapter is land number 1, Indian title. Land number 2 is on the phenomenon of diminishment and disestablishment, which we've talked a little bit about in here. But this one involves mostly eminent domain. And so if I can kind of explain a little bit about that. You probably understand what the definition of eminent domain is. What is the obligation of the federal government when it comes, or any government when it comes to eminent domain? What must the land be? The land has to be the taking of the land by the government has to create a benefit for the general public. It can't be associated with one particular interest. So if there is a cause to take lands, then that cause has to be very, very well substantiated. Number 2, according to the United States Constitution, when the government takes land from individuals, then it must compensate those individuals for that land at fair market value. So there has to be a cause. There has to be a justification for the taking of the land, and there has to be just compensation for the property taken. Well, we know that Indian title is under trust, United States trust land, and we know that only the federal government can declare eminent domain over Indian land. States cannot. In this case, what we're going to see is a claim against the United States for land that was taken prior to the allotment era. And what often happens is there's going to be a settlement, there's a determination of how much land was taken from the tribe. And then the compensation for that taking is calculated in a certain way. So if you calculate it based on and this is the standard, is you calculate it based on the value of the land at the time, and then assume that there's going to be an amount of interest compounded annually on that amount to the present. Okay? And most of the time, if the land is taken, or if the land is, the value of the land is calculated like in the 19th century, the general value of land in the 19th century was usually assumed, at least government land, was assumed to be $1.25 an acre. Okay? And that $1.25 an acre is the base for the calculation of the claim. And so you might have, let's say, 100,000 acres. What is that, $125,000? Okay, so $125,000, but then if that were put in a bank account and was drawing 2% interest or 3% interest annually, and it compounded, then you're going to have a pretty big nest egg up until whenever the claim was made. In this particular one, the case came about in 1937. Went to the United States Court of Claims, which is one of those federal district courts. And the taking had been after, the Shoshone tribe in the Mountain West had this treaty that they were given a reservation of over 44.5 million acres, expanding in 4 states. And then they reduced their reservation. They exchanged it for a 3 million acre reservation in Wyoming that is now the Wind River Reservation. So the 3 million acre reservation is where the claim begins. And this was in 68. So, yeah, 1868. So the government basically said, okay, you all get this reservation. This is all yours for as long as the sky is blue and the waters flow and the grass grows. And so you got 3 million acres basically. And then the next year, during the Indian Wars, the northern Arapahoes, the counterpart of the southern Arapahoes that are here in Oklahoma, the northern Arapahoes were placed on that reservation in 1869. Well, the Arapahoes and the Shoshone never got along. That wasn't good. But the Shoshone, were talked into this by the Indian agent, and the Indian agent convinced them that, okay, well, they're only here for a little while, okay, but just tolerate them for a while and we'll find them another reservation, all right? Kind of like, if you've been in the dorms here, and you have your own dorm, and then the Res Life people say, oh, we need to give you a roommate, we'll cut your cost and all this. That's not fun, is it? So basically they got these roommates that they didn't like, and tensions started building between, during the 1870s. And see, well, maybe that was 1878 when they did that. Anyway, the Northern Arapaho wind up occupying part of their reservation. And the Shoshone are saying, okay, well, the Indian agents said that Washington will find them another reservation and they'll move away. But what happened was, even though the Shoshone petitioned to, say, hey, when are our roommates here? When are the Northern Arapahoes going to be removed from our reservation? And the federal government basically blew it off. The Indian office just didn't give them an answer. The Shoshone agency was even trying to do this. And finally, in 1891, the Bureau of Indian Affairs in Washington said that the Arapahoes will now stay permanently and the Shoshones can't do anything about it. Okay? So they said, oh, they're going to be there to stay. We don't have another place for them. And, gee, that was... There wasn't any writing. There wasn't anything broken. It was all, just kind of a verbal agreement. So the Shoshone said, okay, well, in 1927, they're saying, okay, they've been here for like 30 years, and if you would please, or 40 years, if you would please, 50 years, right? If you would please, we'd like to be compensated for the value of the land that they have on this reservation, and we'd like that calculated with interest over the previous 50 years or whatever. This is all before the United States Indian Claims Commission. So the Court of Claims is dealing with this, and so the government recognized its obligation, its breaking of a trust obligation to the Shoshone. Basically, gave them a reservation, promised it to be theirs, then we moved other people onto it. And so they didn't have everything they weren't getting everything they were promised for 50 years. So then became the issue of how to calculate the compensation. And the Shoshones wanted to have the value of what the land was worth at the time of the taking, which would have been 1878. Okay, so the value of the land at the time of the taking plus compound interest over 50 years. But the government says, no, we'll pay you what it was worth beginning in 1891 when we told you that they were going to stay permanently, because that's sort of like establishing a reservation for them. And that's what this case settled. But it sort of was kind of a wash, because the value of the land in 1891 was a little higher, than what the total would have been with compound interest. Both of them were calculated with compound interest. And the lessons of this, the other lessons of this generally, is that government inaction was the problem. So the violation of trust was the federal government not doing something to correct a problem that it had created for the tribe. So the government can violate trust by inaction, by not doing something.